Hello, everybody. Thank you for joining us and taking your time out to watch this presentation. I'm Edmund Townsend, and the other figure that you can see on the screen there is Michael Standing. We're going to speak to you today about road traffic accidents and vulnerable road users. It's now established government policy to encourage people to engage in more physical activity, walking and cycling. So it's constructive to encourage people to commute by that means to assist with pollution, and also health concerns surrounding obesity. You're probably all looking at the photo of me and thinking, I'm partly responsible for this. You're all thinking it, so I might as well say it. And obviously the COVID pandemic is likely to continue that trend, because earnest people will want to commute without using public transport where that's possible, or because gyms are shut, they want to be able to exercise in ways in which they hadn't done previously. Or less earnest people might just want a way of escaping from their spouse or their children, having spent too long locked up with them. So all that means that we're going to have more walkers and cyclists on the road, and obviously that comes, what comes with that is the potential for conflict between those vulnerable road users and other road users. And anybody who's ever traveled by black cab in London will know the potential for that conflict, because you hear no end of it from taxi drivers whilst you're getting your journey. But we will hope to provide a less biased analysis. We won't be quite so prejudiced against cyclists. And so what we're looking to cover today is essentially looking at the prospects of primary liability attaching, and where it does attach, whether there's contributory negligence, and what the apportionment will be, if any. And so we will review some of the principles that underpin those considerations. We'll look at some of the recent decisions with a view to assisting you in reaching those assessments. And also we'll touch upon the consultation about the review of highway code and whether that ought to be changed. Obviously, there's constraints about what we can deal with during the course of a 1-hour webinar. So if you want to look at these issues and explore them in a bit more detail, Emily Formby QC and Caroline Hall of DAC Beechcroft are both keen cyclists, and they've been preparing a series of podcasts called Wheel Life that are available on 39 Essex Chambers website. So please do look at those. You should be able to find them easily on the website. If not, please do get in touch with the clerks and they'll be able to provide you with a link. Michael's now going to remind us of some of the underlying principles that will apply to these situations.
Thanks very much, Ed. I think you're definitely not the only one that's maybe carrying a few COVID pounds as a result of the lockdowns. I think this probably applies to lots of people on this call, certainly myself included. Turning then to the duty owed and the standard of care, this is obviously a factor that's going to be familiar to everyone, but it's obviously worth touching upon. So to start with, the standard of care, a driver is judged objectively. What we're looking at is what is the reasonable road user. And the classic quotation that we have is from Mr. Justice Coulson, as he then was in Stewart and Glaze. He stated, I have to apply to the defendant's action the standard of the reasonable driver. It is important to ensure that the court does not unwittingly replace that test with the standard of the ideal driver. It's also important to ensure, particularly in a case with accident reconstruction expert, that the court is not guided by what is sometimes referred to as 20/20 hindsight. And I think that's an important point to bear in mind. It's very easy when you're dealing with a case with reconstruction experts to become incredibly technical and start talking about what might or might not or should not have occurred in fractions of seconds. In most cases, there will be a range of what a reasonable driver might have done. There's often going to be an ideal response where a driver can react very, very quickly and do precisely what is required, but that is not always going to be what a reasonable driver will do. Often there is a range of factors, there are a range of reaction times, and it's very important to bear that in mind, particularly when you're dealing with reconstruction evidence, because there is a tendency, I think, to get slightly tunnel focused on what the ideal driver might have done. I'm afraid Ed's in control of the slides, so I feel a bit like Chris Whitty here, and I'll ask him to move forwards each time. Dealing then with breach and foreseeability of harm. The question then is what, therefore, is it reasonable for a driver to do? And we have the very often quoted passage from Lord Uthwaite in London Passenger Transport Board and Upson, where he states that I dissent from the view that drivers are entitled to drive on the assumption that other users of the road, whether drivers or pedestrians, will behave with reasonable care. It is common experience that many do not. A driver is not, of course, bound to anticipate folly in all its forms, but is not entitled to put out of consideration the teachings of experience as to the form those follies commonly take. It's an excellent use of the word folly, and doesn't come into judgments enough, in my opinion. But it raises an important point, simply that people, when using the road, you can't rely on others not to do something stupid. And for present purposes, the primary example is likely to be a driver driving along the road, perhaps sees a group of pedestrians waiting to cross in between traffic. If they look like they're likely to cross, it's probably reasonable for a driver to think it's a possibility that they might in fact cross, even if they shouldn't, and even if it would be a very stupid thing to do. It's potentially reasonable for a driver to anticipate that and to potentially take action in covering the brake, potentially easing off, keeping an eye on them. So it's something to bear in mind, to keep those follies in mind. Ed, next slide, please. We then come to the highway code. Obviously something that's very important in all RTA cases, but it's worth bearing in mind it's a code rather than actually being legislation itself. It is, however, a useful tool. It's a useful tool particularly for claimants, and we'll often see it pleaded in the particulars of claim where there's a reference to a breach of the highway code. It's worth mentioning section 38(7), which states of the Road Traffic Act, which states that a failure on the part of the person to observe a provision of the highway code shall not of itself render that person liable to criminal proceedings of any kind, but any such failure may in any proceedings, whether civil or criminal, be relied upon by any party to the proceedings as tending to establish or negative any liability which is in question in those proceedings. So it's a useful point, and as was made clear in Goad and Butcher, a failure to observe the code may be evidence of negligence, but whether it will depend very much on the circumstances in which the act in question was committed and who is the claimant. So the breach must, of course, be causative to have any effect. And if we imagine a situation perhaps where a motorist is travelling on a motorway over the speed limit at, say, 73, 74 miles an hour, if a claimant steps out 3 meters in front of them, obviously that driver is going to have no time to stop, whether they're traveling at 70 miles an hour or 73 miles an hour, if that was a reasonable speed to be traveling. It would likely be a pretty brave expert to say that that difference in 3 miles an hour would make a substantive or causative difference to the injuries sustained. So in a situation like that, the fact that they're speeding is perhaps much less likely to be relevant. It's a point worth mentioning, though, all of these cases that we're going to deal with do turn on their facts. whilst help can be derived from other previous authorities, everything in this is very fact specific, as the authorities make clear, and I think that's a point that Ed will touch upon as well.
Sure. Contributory negligence, as with so much of the common law, it's always helpful to see what Lord Denning had to say. Contributory negligence is a man's carelessness in looking after his own safety, is guilty of contributory negligence if he ought reasonably to have seen that if he did not act as a reasonable, prudent man, he might be hurt himself. The burden is on the defendant to plead and prove contributory negligence, and to prove that that negligence was causative. And it's always worth bearing in mind the practical realities of that. So if there is an admission of primary liability, then you might well find as the defendant that you will be opening the proceedings because you bear the burden of proving the issues in the case. And that might influence the way in which you prepare a case or think about it. And it may influence whether you wish to make an admission of primary liability in the first instance. In terms of the apportionment, Davies and Swan is the helpful case there. The amount of the reduction is such an amount as may be found by the court to be just and equitable, having regard to the claimant's share in the responsibility for the damage. This involves a consideration not only of the causative potency of a particular factor, but also of its blameworthiness. So there's two considerations that underlie the apportionment once there is found to be contributory negligence, and that's the causative potency of the negligence of the motorist and of the contributory negligent party, and also moral blameworthiness. The concept of blameworthiness on the face of it is perhaps nebulous, and so could give rise to differing views between different judges. And so Baker and Willoughby is an example where there was a decision at first instance, a finding of 25% contributory negligence that was appealed successfully in the Court of Appeal. They substituted their own finding of 50%, but then the House of Lords returned back to 25%. And Lord Reid there stating, there are two elements in an assessment of liability, causation and blameworthiness. I need not consider whether in such circumstances the causative factors must necessarily be equal, because in my view, there is not even a presumption to that effect as regards blameworthiness. A pedestrian has to look both sides as well as forwards. He's going perhaps 3 miles an hour, and at that speed is rarely a danger to anybody else. The motorist has not got to look sideways, though he may have to look to observe over a wide angle ahead. And if he is going at a considerable speed, he must not relax his observation, for the consequences may be disastrous. And it sometimes happens, though I do not say in this case, that he sees that the pedestrian is not looking his way and takes a chance that the pedestrian will not stop and that he can safely pass behind him. In my opinion, it is quite possible that the motorist may be very much more to blame than the pedestrian. And in the present case, I can see no reason to disagree with the trial judge's assessment. So that touches upon the disparity of the relative positions of a pedestrian and a motorist that Michael will build upon later and talk about eagle. And because there is always likely to be a range of opinion amongst judges, it is difficult to appeal findings of an apportionment. So there's a quote there from Lord Reid in Jackson. Lord Reid also said elsewhere in Jackson, apportionment of responsibility for an accident is inevitably a somewhat rough and ready exercise, and a variety of possible answers can legitimately be given. And when you bear that in mind, you can then see the sense of the quote that is set out there, that in the absence of an identifiable error, such as an error of law, or the taking into account of an irrelevant matter, or the failure to take account of a relevant matter. It is only a difference of view as the apportionment of responsibility which exceeds the ambit of reasonable disagreement that warrants the conclusion that the court below has gone wrong. In other words, in the absence of an identifiable error, the appellate court must be satisfied that the apportionment made by the court below was not one which was reasonably open to it. So very much akin to the approach that you would have with a finding of fact. There will be a range of ways of analysing the situation in terms of an apportionment, and you're going to have to show that a judge has gone beyond that range in order to successfully appeal, unless you can show that they've taken into account something that they ought not to have done, or that they failed to take into account something that they should have, or that there was an error of law. So when you're analysing cases, I think it's very helpful to have in your mind that it's not an exact science, that it's not subject to a binary outcome. You need to try to anticipate what the likely range would be. And that's something that should inform your negotiations in the case. And very often tactically, what is prudent is to try to steal the middle ground. So where you identify a range of potential apportionments, stealing the middle ground is often a way of adopting quite a powerful position that puts the other side under a lot of pressure. So Michael's going to talk you through Pedestrians now before we then turn to look at some cases.
Thanks, Ed. Pedestrians, obviously the most vulnerable of road users, and then particularly so if very young, very old, or disabled. They have no protection and lack the speed to escape injury. Pedestrian cases are normally the ones which are pleaded to the highest value. The injuries sustained by pedestrians versus cars are often catastrophic. The usual battleground is the level of contributory negligence, if any, that can be established against a pedestrian. Where a pedestrian is struck on the road, there will normally be some finding against the driver, unless there's a situation essentially where the driver could not have reasonably done anything. So there's relatively rare situations where a pedestrian steps out in front of a vehicle and there's simply nothing that can be done. There are relatively few reported judgments where those findings are made, where the defendant isn't liable at all. Part of the reason, though, is probably because in cases like that, there will often be situations where the defendant makes relatively low ball offers, where the claimant's case is relatively weak, and those are accepted and they're simply not fought to trial. But we will touch upon a few cases where a defendant does manage to successfully defend these matters. It's worth noting, as I said previously, that all of these cases turn on their own facts. The authorities are of relatively limited assistance. They're good for ballpark figure checking and sense checking on the percentages, but it's repeated in so many of the judgments that they all turn upon their own facts, and they're not necessarily meant to be indicators of definitive percentage divisions. Ed, can I have the next slide, please? So destructive disparity, cars versus pedestrian. This is the quote from Eagle and Chambers that appears, I think, in pretty much every claimant's skeleton argument in cases of this nature. So a car can do so much more damage to a person than a person can usually do to a car. The potential destructive disparity between the parties can readily be taken into account as an aspect of blameworthiness. And it is rare indeed for a pedestrian to be found to be more responsible than a driver, unless the pedestrian has suddenly moved into the path of an oncoming vehicle. So Lady Justice Hale, as she then was, her words you will see again and again in cases of this nature. And the point is relatively simple in that regard. Because of the damage that can be caused, by a car, and because of the fact, as seen in London Khalifa below, that a car is a potentially dangerous weapon, there is a higher duty on the road users. Driving a car is inherently dangerous. When doing something that is inherently dangerous, the duty that is owed is likely to be higher. And what is expected of a driver, because they can cause such damage, they're likely to be held to a higher degree of blameworthiness if they fall below that. It's an important point just to bear in mind. The next slide, Ed. So moving to some examples of pedestrian versus cars. The first one we're going to start with is Woolridge and George, and this was a judgment of Her Honour Judge Walden Smith, sitting as a High Court judge. This accident occurred just before midnight. The defendant was driving a VW vehicle when she struck the claimant as he was slowly crossing from one pub to another, having been drinking. It was a slightly unusual case in that there was no evidence at all that the defendant was in any way distracted. She wasn't following sat-nav, she wasn't engaged in a conversation, there was no evidence that she was on her phone, she wasn't speeding, she was travelling at around 20 miles an hour. This was a two-lane road, defendant driving in the right-hand lane and intending to turn right. And the evidence from the reconstruction experts agreed that the defendant would have had about 6 seconds to see the claimant before she collided with him. There was an independent witness who had seen the claimant, who was being beckoned to by someone on the other side of the road. That witness said the claimant was clearly intoxicated, was walking and moving very slowly, and saw the claimant enter the left-hand lane. It was clear that he was staggering and swaying, and noted that it took him a very long time to get to that position, and then said that the claimant walked to the broken line in the centre of the road and came to a total stop and waited there for a good few seconds, apparently as if he had seen the defendant's car. The evidence was then that the claimant stepped forward as essentially the car passed him, effectively stepping directly into the defendant's path, when there was nothing by that stage that could be done to avoid the impact. So whilst this was a case where the claimant effectively stepped directly into the defendant's path, it was a case where the claimant was already in the road and was there to be seen. In simple terms, the court found that the defendant should have seen the claimant standing in the road, should have appreciated the claimant posed a very real danger, and ultimately that although the defendant didn't see the claimant, that there was no real reason why she shouldn't have done. There were street lights, and the finding was made that from around 60 meters away, the claimant would have been visible to the defendant. The claimant was found to be contributory negligent to the tune of 30%. In terms of being drunk, we'll touch on intoxication briefly, but being drunk of itself was not a reason for the finding of the contributory negligence. His negligence was the act of being in the road and stepping in front of the car. The fact that he was drunk was maybe the reason why he did that, but it wasn't the reason itself for the negligence. There's not a huge amount of reasoning in the judgment for why we get to the 30%, and it's often difficult, I think, for judges to expressly say why one percentage fits better than another, and there's always a feeling that there's a slight finger in the air approach, but 30% was found to be appropriate in this case, performing what was an inherently dangerous act by the claimant in stepping out into the road, even though there was an expectation that he could and perhaps should have been seen. Ed, back to you, I think.
Yeah, thanks. And the next case is Brahma and Hassan. The claimant again suffered catastrophic injuries when struck by the defendant's motor vehicle. The claimant was given a lift by her employer to a tube station, dropped on the opposite side of the road, got out of the vehicle on the off side, so into the carriageway, but went behind the vehicle to the pavement nearest to her, and then at that point needed to cross the road to get to the tube station to continue her journey home, and needed to cross 4 lanes in order to do so. She had crossed 2 lanes by the point that she was struck. There was an issue as to whether the vehicle that had dropped her off would have obscured her from view of the defendant driver, but on any analysis, for at least 2.5 seconds during her 4.5 second journey across the road, she would have been there to be seen. There was a finding that the defendant driver was traveling at 30 miles an hour. That was found to be too fast in circumstances where it was an urban area in London. There was a tube station and it was dark and wet. And the apportionment in this case was of a discount of 20% for contributory negligence. The claimant had misjudged the approach of the defendant, plainly wasn't aware of how quick the defendant was traveling. The claimant was wearing dark clothing on her upper body in hours of darkness, which does make it far more difficult to see people. And I always have a degree of sympathy with motorists because I think you can draw upon your own experience of driving in darkness, and people in urban streets wearing dark clothing, they often are difficult to spot, but it's difficult to argue that that's a significant factor when it comes to contributory negligence, because it's so common for pedestrians to wear dark clothing, and it isn't always the case that pedestrians have the same obligation as, say, a cyclist to wear reflective clothing. So although there were a number of potential criticisms of the claimant identified by the judge, only a finding of 20%. There wasn't really, as Michael suggested earlier, there wasn't really a large amount of detail in expressing the reasoning that underpinned that decision. It's certainly at the more generous end of the range that could be applied in that case. Indeed, I think I'm right in saying that the 20% was what the claimant's representative had contended for during the hearing. That rather suggests that it's the top end of the range, because that's really what you would expect at trial, that the representatives for each party would be pitching at the respective ends of the range, and then the judge will make a decision. So it's perhaps a generous decision, but overall, you can certainly see that the motorist in that instance is traveling in excess significantly of the speed that would be safe to be traveling, did not really see the claimant. There wasn't really a reasonable excuse for failing to see the claimant. And in those circumstances, given the case law that Michael's taken you to previously in relation to the disparity between a pedestrian and a motorist, 20% is certainly a foreseeable outcome, even if it is at one end of the range. And O'Driscoll really sort of picks up on the point that I mentioned in the last slide about clothing. So in O'Driscoll, the claimant was struck by the defendant's vehicle whilst he was crossing a side road. It's in an urban area. He was traveling along a pedestrian footway. He didn't stop as he was crossing that side road, and the defendant turned right into the road. he cut the corner significantly, and in doing so collided with the claimant. Primary liability was admitted in that case, so the only issue was whether the defendant could establish contributory negligence. And obviously the arguments focused on whether the claimant had failed to keep a proper lookout, but also in relation to the clothing that Mr. O'Driscoll was wearing. Because the arguments in relation to lookout fell away a bit at trial because of the performance of the defendant driver. There was inconsistencies in the defendant driver's evidence, and in those circumstances, His Honour Judge Sefton was not willing to make a finding as to when the defendant driver had indicated his intention to perform the manoeuvre. And the consequence of that was that the judge then in those circumstances was not willing to make a finding that the claimant had failed to observe the indication. And so that really stripped the defendant of their ability to successfully argue a case about proper lookout, because they couldn't establish that the indication was there to be seen and the claimant should have picked up on that, and that it wasn't then safe to cross when he did. In those circumstances, in the absence of a finding as to when the indication was, the claimant had no reason for knowing that it would be unsafe or inappropriate to commence crossing the road. And being on the side that he was, he wouldn't have come into conflict with a motorist travelling in the direction of the defendant until he'd got at least halfway. And in His Honour Judge Sefton's view, once he got halfway, at that point, one might have expected a motorist to stop to allow him to travel. So really, given the case on proper lookout collapsed a bit at trial because of the inconsistencies of the defendant driver, there was then a greater focus upon the clothing that Mr. O'Driscoll was wearing. And really the take-home point from O'Driscoll is it highlights that it's very difficult to get home on a case of contributory negligence simply because of clothing, because of course we all go out as pedestrians, and how many of us wear reflective clothing? It's not something that is perhaps given as much consideration when it comes to pedestrians as it would be for cyclists. And so you can see, given everybody's practice in terms of what they wear, it is difficult to then make a finding of contributory negligence solely because of clothing. And certainly not in the circumstance of this case, where it was an urban area and there was reasonable street lighting. I think probably in order to establish contributory negligence in relation to clothing, you'd probably need to be able to establish some atypical circumstances. So perhaps it may be of greater consideration where somebody is in a rural area where it's not well lit, where it might be said that they are taking a risk in going out. It's more foreseeable or obvious that they would be putting themselves in a position of danger because it would be less likely for them to be seen. But here, this was an accepted pedestrian walkway in an urban area that was well lit, so there was no reason for the claimant to have thought that his clothing would put him in a position of danger. And then next, before I hand back over to Michael, we've got the case of Warsam and the London Fire Brigade. Here, the claimant was injured when she was hit by the wing mirror of the fire engine that was responding to an emergency call. So the fire engine was displaying its flashing lights and siren. And the claimant had been to a party where she drank wine and smoked cannabis. She hadn't drunk alcohol or smoked cannabis for 2 years beforehand. So there was a finding of fact that it was likely to have more effect upon her, and also because it may interact with medication that she was taking. The claimant was involved in an altercation outside a kebab shop and called the police in relation to that. And when the fire engine was approaching, she believed that the sirens were a police vehicle, and so she stepped into the road to try and attract their attention. There was a finding of 50% contributory negligence in that case. So it's an example where, despite the potential disparity between a large fire engine and a pedestrian, the court was willing to find equal contribution between the two parties. And that was because the claimant had moved in a rapid fashion between two parked cars that were in the bus lane, and that obscured her from view to an extent. But being that she was at a kebab shop, there was a group of 10 to 15 pedestrians on the pavement outside the kebab shop. It was Commercial Road in London, which is a road that is always busy, and that was accepted by all of the defendant's witnesses. So the driver on driving through Commercial Road would have been or should have been aware that there was potential hazards in such an urban area, even though it was very early in the morning at 3 a.m. The defendant's driver was driving too quick in the circumstances, 45 miles an hour. The evidence of his colleagues was that in responding to an emergency in those sorts of conditions, it would be difficult and rare to get up to 30 to 40 miles an hour. But notwithstanding that, the evidence of the accident reconstruction experts was in agreement that before the accident, the defendant was driving at 45 miles an hour. That was found to be far too fast in the circumstances and significant causatively, because if he was driving at a slower speed, he would have been better placed to be able to take avoiding action. He didn't really, the defendant driver in that case, didn't really apply emergency braking. When he did brake, he stopped short of emergency braking. In that case, it's quite interesting because there is a slightly more detailed explanation of the apportionment and how it was reached by Anne White QC, sitting as a deputy judge of the High Court, and she took the time to particularly separate out the consideration of causative potency and blameworthiness. And in relation to blameworthiness, it was expressly taken into account that the claimant in her actions had placed herself in an obviously dangerous situation, misjudged the speed of the fire engine, and that conduct had impeded the legitimate and important work of the fire service.
Thanks, Ed. I should say before we move on, we do have the Q&A function open. I can see we've had one question already. If anyone does have questions as we go along, feel free to type them in there. It's all anonymous. We won't be naming and shaming anyone with any questions they've asked. If you do have questions, feel free to put them in there. We might regret saying this later, but we'll hopefully be able to deal with a few of them at the end. And those that we can't, we'll endeavour to get back to following the end of the seminar. The case of Gull is a very recent decision earlier this year. In my view, a pretty good result in the circumstances from the insurer's point of view, getting a 10% contributory negligence finding. I can see how there would have been advice given before this that there would be no contributory negligence found. To me, it seems slightly surprising. But as I say, a good result if you're the insurer, perhaps a less good result if you're the claimant. So the claimant was a 13-year-old and he was struck by the defendant as he crossed the road. The defendant had previously been convicted for this piece of driving, of dangerous driving. The sentencing remarks at his criminal hearing were that the driving was appalling, reckless and furious driving. He was driving at 45 miles an hour in a 20-mile-an-hour zone in a built-up area with lots of pedestrians around. primary liability was conceded, and so the only issue to be determined was contributory negligence. Now, dealing with contributory negligence, children can, of course, be found to be contributory negligent. The age at which they can be found, well, it essentially depends on whether they can be found to be blameworthy for their actions. Clearly, a very, very young baby or toddler is not going to be found to be contributory negligent for anything because they're not blameworthy. As far as we're aware, there are no reported cases of contributory negligence for children under the age of 8, but there certainly are for 9-year-olds and upwards. Going back to another Lord Denning quote in Gough and Thorne, a very young child cannot be guilty of contributory negligence. An older child may be, but it depends on the circumstances. A judge should only find a child guilty of contributory negligence if he or she is of such an age to be expected to take precautions for his or her safety, and then he or she is only to be found guilty if blame should be attached to him or her. A child has not the road sense or experience of his or her elders. He is not to be found guilty unless he or she is blameworthy. If I can just flick to the next slide, please, Ed. So in terms of contributory negligence, it was found that it was generally expected that a court will impose a high burden on drivers to reflect the fact that a car is potentially a dangerous weapon. We've heard that quote before. The first defendant's driving in this case was particularly egregious. His speed was excessive, the risk of injury obvious, and his motivation, the desire to avoid arrest. So this was driver was actually on the escape from the police at the time. Insofar as the claimant could see the defendant, so too the defendant could see the claimant and could and should have slowed down. It would not have taken much adjustment on the part of the defendant to allow the claimant to complete that final 30 centimetres across the road. The causative potency of all these facts is extremely high and must weigh heavily against the first defendant. So as I say, this was a case where the claimant was crossing the road and it very almost reached the other side of the road, only 30 centimetres from the other side, when the defendant, driving essentially like a lunatic, far too fast, collided into him. The defendant hadn't proved that the claimant didn't look to his right before crossing the road, and there was a finding made. There were headphones found at the scene, which were the claimant's headphones, which the claimant was likely wearing at the time the finding was made. Now, of course, it's not negligent to wear headphones. However, if you do wear headphones, it was found it's more important to look carefully when crossing, because of course the ability to hear a vehicle is limited. In this case, it's slightly unusual. The evidence was that the defendant's driving was so bad that it should have been more obvious to the claimant that he was approaching very quickly. It seems slightly counterintuitive to me that because the driving was so bad and so obviously bad, that should somehow be a slight saving grace for the defendant, and that the claimant should have noticed it. The judge's finding was that a reasonable 13-year-old would have considered that the focus approaching in such a manner represented a source of danger and would have waited for the focus to pass. Even if a reasonable 13-year-old had set off, they would have kept the forward focus under observation so that if necessary, they could hurry across the very short distance. This was a case where a 10% reduction was made for contributory negligence. In the circumstances, I think that's, as I've said, a good result for the insurers and a slightly tough one for the claimants. But as Ed said, that there is always a range in these circumstances.
Yeah, I think I would just add to that, Michael, that when you start to look at 10%, normally when I am analysing a case, if I start to look at whether there's a 10% contribution, I'd probably start to query whether there's any contributory negligence at all once you get...
Exactly. I mean, I certainly, when I'm advising on contrib, I normally have a bigger range than 10%. So, and the bigger range than 10% is down to 0.
Yeah, it's not a very common finding, and I think that probably demonstrates that it's quite an atypical case.
Yeah, I agree. We then have another very, very recent case, case of Barrow and Merit. This was a judgment handed down in March this year. This was a bit of a 39 Essex Chambers party. We had Susan Campbell, QC leading James Burton, both in 39 for the claimant, and Derek O'Sullivan, Queen's Counsel, also from 39 for the defendant. Sorry, this is Susan Rodway. I've completely said her name wrong. And judgment in judgment in March this year, where a claim was dismissed against an 11-year-old claimant crossing the road, so a fully successful outcome for the defendant. It's a useful analysis, in this case, the assessment of witness evidence and the importance of contemporaneous account. It turns on factual evidence of precisely what had happened. And the case really turns on whether the claimant was in the process of getting up from falling or was struck moments after he had run and fallen in the road. Now, the claimant himself had no memory of the accident and couldn't give evidence at trial. And the evidence came from the claimant's friend, an 11-year-old at the time, who, causing some difficulty to the claimant, as found by the judge, had given at least 5 accounts of what had occurred at that time. Both parties essentially accepted that if the other side had proved their case, so if the claimants could prove that he had been in the road, had been in the process of getting up, they would be successful on primary liability, because clearly the defendant driver should have seen. And equally, the defendant would be successful if they could show that the claimant had run into the road and had fallen almost immediately before being struck, because there was nothing that the defendant could do. It's a good example, this case, of some of the difficulties that claimants can face in this type of accident. It's very common that claimants themselves don't remember anything. So all you are left with is any witnesses that might be there. And in this case, it was the claimant's friends. There was an interesting analysis in this, and the submissions made by Susan Rodway in relation to this, to the Guestman principles, that they stem from the case of Guestman and Credit Suisse, which deals essentially with the importance of contemporaneous evidence in cases of this nature, or cases more generally. And it's worth reading that case, and it's not particularly specific to pedestrian type claims, but here the court noticed some of the factors which impacted upon the claimant's witnesses' ability to recall what had happened. And he noted that people generally lack insight into just how reliable memory can be. Memories are often fluid and malleable. The process of civil litigation itself subjects memory to powerful biases. And it was said here that a desire to assist a party or to not prejudice them, as well as a desire to give a good impression, can be powerful, but subtle factors impact upon the reliability of memory. And that the effects of giving evidence can also materially impact upon memory. The judge in this case ultimately found that the original account given by the claimant's friends, the police officer at the scene, was likely to be the correct one. And the court found that the defendant's account was probably correct. It was clear that the judge found this a relatively difficult case. There was no CCTV evidence, no dash cam evidence, which meant that the reconstruction evidence was a little more limited in that regard. But ultimately the finding in that case, this was a claimant who had unfortunately slipped over very shortly before the vehicle arrived, and there was nothing that could be done in the circumstances. So the defendant simply was not liable. It's another example of a finding, which are relatively rare, of the defendant not being liable in any way. Thanks, Ed. A quick note on pedestrian crossings. The starting point is that where possible, pedestrians shouldn't cross between cars, but there's no obligation to use pedestrian crossing. There's no rule against jaywalking as we have in the States. The Highway Code at Rule 14 deals with parked vehicles and says that if you have to cross between parked vehicles, use the outside edges of the vehicles as if they were the curb, stop there, make sure you can see all around that, see the traffic can see you. Never cross the road in front of, behind, or any vehicle with its engine running, especially a large vehicle, as the driver may not be able to see you. So I think the most important point to think about there is, in respect of parked vehicles, if you have to, it's whether the claimant has to cross between the parked vehicles. Is there an easier option for them to take? Is there a pedestrian crossing nearby which they should be using? And that's likely to impact on the reasonableness and therefore the blameworthiness of their actions. And a quick example of that, Adams and Gibson, the claimant was struck when crossing the road, had been drinking, another intoxication case. The impact occurred just before a pedestrian crossing, where the defendant had failed to see the claimant once he stepped into the road. And that was a case where the claimant's damages reduced by 1/3. Essentially, the findings were he failed to look as he stepped out, and he failed to use the pedestrian crossing that he could have done. Again, emphasis by the court on fact sensitive, but a 1/3 reduction, in my view, that's likely to be a fairly common type of reduction in a case like that. Those are the kind of figures you would expect in that sort of matter. Thanks, Ed.
Yeah, intoxication we've touched upon previously. I think that anecdotally, I would say that when I discuss cases with people, intoxication is one of those issues that is often perhaps given greater emphasis than it should be. Really, strictly speaking, the fact that you are drunk is not something that of itself means that you're going to have an accident. And so it's not something that is necessarily causatively relevant. It's really what you do that is relevant. And so it may be that you act in that way because you are intoxicated, but the fact of the intoxication is really just part of the facts. So Liddell and Middleton is the case that is authority for that proposition. Lord Justice Stuart Smith, it is not the fact that a plaintiff has consumed too much alcohol that matters, it is what he does. If he steps in front of a car traveling at 30 miles an hour at a time when the driver has no opportunity to avoid an accident, that is a very dangerous and unwise thing to do. The explanation of his conduct may be that he was drunk, but the fact of drunkenness does not, in my judgment, make the conduct any more or less dangerous. And it does not in these circumstances increase the blameworthiness of it. Cyclists are obviously using a vehicle themselves, so they are perhaps likely to be given a higher responsibility than pedestrians often will be. But still, when you pause to consider the relative harm that can come of a cyclist error in operating their bicycle with that of a motor vehicle, there's still a greater disparity for harm being caused. And so there is likely still to be some consideration of disparity between the vehicles when you take into account apportionments. You're going to have far better scope arguing about clothing with cyclists because it is such a relevant issue that most cyclists are aware of, their conspicuity and whether they can be seen, and the need to have visibility, clothing or lights in hours of darkness. Rickson and Barker is another Derek O'Sullivan case, so he's getting lots of coverage here. I hope he's happy about that. That's a case where the claimant cyclist was found to have been contributory negligence. The cyclist was participating in a time trial on the A27, so a dual carriageway, quite a substantial road, and the defendant was driving a van traveling in the opposite direction and wished to turn right across the claimant's path. The claimant suffered serious injury, didn't really have recall, and so there was expert evidence from accident reconstruction experts, and they were able to establish that the defendant started the turn when the claimant was about 40 meters away. It was admitted that the defendant was liable, having failed to see the claimant, and there'd been a criminal prosecution in that respect. So primary liability was admitted, and the only issue was whether the claimant had contributed. And the findings of fact were that the collision had occurred in the middle of the near side lane. And so by that point, the van had traveled between 9 and 10 meters and had been traveling at 10 miles an hour. So there was a window of opportunity for the claimant cyclist to have seen the van of about 4 seconds, and the claimant had had a long, clear view, and the claimant did not slow on approach. So the claimant tried as a last-minute reaction to swerve to avoid a collision, but hadn't slowed on approach. And if the claimant had slowed, the accident would have been avoided entirely, because the impact with the defendant van was in the rear wheel. So the van had near enough got across and cleared the carriageway by the point of the collision. So there was a finding of contributory negligence in that case, and the apportionment was 20%. And I think, again, that just probably demonstrates the range, because obviously it was a good finding for the defendant to secure a reduction in respect of contributory negligence. But if you pause to consider the facts of the case, certainly I don't think you'd find that it would be appealable if there was a finding of 25% or 30%. So it demonstrates that there is always a range again. And Elson and Stilgo is a case where there was found to be no primary liability at all at first instance. So there was an appeal to the Court of Appeal in respect of that. The claimant cyclist was riding with a friend. It was 8 a.m. January morning, so it's still quite dull, not bright. The claimant was not wearing high visibility clothing, had no lighting, was overtaking a line of stationary traffic. There was a factual dispute as to how they were riding, whether they were riding side by side or in single file. And the evidence of the claimant, the person they were riding with, and an independent witness was all consistent that they were traveling single file. The judge preferred, though, the evidence of the defendant that they were traveling side by side. The judge at first instance didn't really give reasons for preferring the defendant's evidence, so you can probably see why there was an element of sour grapes on the part of the claimant and a wish to appeal. But crucially, the judge had said on either basis they did not think that the defendant was negligent. And essentially, this is just a case that was decided on its facts, on the basis of factual findings, because the effect of the judge's findings was that the claimant had crossed over onto the defendant's side of the carriageway and hadn't been there for any length of time sufficient to be observed in a way which required the defendant to take any evasive action. So the claimant had veered into the defendant's lane on their side of the carriageway without good reason for doing so, and at the last moment, and so not affording the defendant an opportunity to take evasive action. So in many respects, you can see that as a similar sort of reverse inversion of Rickson and Barker, in that you've got, in this instance, the cyclist creating a potential situation of danger, and it's being alleged that the motorist was failing to respond to that and take action. But the difference, crucially, between those two cases is that in Rickson, the cyclist had a long window of opportunity to see the van performing its manoeuvre, so it was there to be seen in a way that did require evasive action. Whereas in Elson, it was found to be at the last moment. So that's really the difference between those. And Michael, I'll hand back to you for the last case.
Thanks, Ed. I can see that we're running slightly over time already, so I might skip, if we skip through perhaps to motorcyclists,
Yeah, sure.
just to touch on that briefly. We could do a whole talk on motorcyclists. There's a large body of case law in this area, but just to touch on a few of the most important points. I think filtering is perhaps the most important matter to consider with motorcyclists. I've done a number of claims involving motorcyclist filtering, both for claimants and defendants, Ed, and I'm sure you've done a number of these too. It's worth remembering the quotation from Clark and Winchurch: a motorcyclist in the fortunate position of taking up so little road space that you can slide along the offside of stationary traffic, but that such a manoeuvre warrants a very, very high degree of care indeed. It's worth noting filtering is an entirely legitimate manoeuvre to carry out, though the risks are very, very high in doing so. As such, the driver must take very great care. Equally, motorists are required to take care and to use their mirrors in doing so, but it's not them that is performing the dangerous manoeuvre, it's the motorcyclist rather than the car driver. In terms of the rules in the highway code, you have Rule 88 and Rule 167. It's simply worth sort of noting that the contrast in them between what's required in terms of filtering versus what's required in terms of overtaking, because you are able to filter when going past a junction. It's just the requirement is going to be you have to take very, very high level of care, because there's obviously the chance that people are going to be turning. I'll go to the next slide, Ed. Thanks. Creature and Finch, a scooter driver, was able to establish primary liability against the defendant car driver, but with a finding of 80% contributory negligence. This was a case where driving a moped scooter in a pretty dangerous way, 50 miles an hour down a single carriageway towards a junction, overtaking a van. The defendant's vehicle was travelling at a much more reasonable speed, around 14 miles an hour, coming in the opposite direction, and was turning right at the intersection, but unfortunately cut the corner as he did so. The claimant didn't give evidence at trial. There was certainly a suggestion that he had been or had cannabis in his system, was under the influence of that, and an adverse finding was made to that effect on the basis of him not giving evidence. In that case, it was held that defendant was negligent in failing to see the claimant because he cut the corner. Had he stayed and held his line, he would have been able to see the scooter coming towards him. The claimant, however, was driving at a speed around twice the speed limit, performing a very, very dangerous manoeuvre, overtaking near a junction. The defendant's risks in cutting the corner were momentary, whereas the claimants were over a sustained period of time and of a much, much greater magnitude. And as a result of that, it was held that a huge proportion of the blame lay with the claimants, namely 80%. And in those circumstances, I think it's relatively easy to see why it's such a high level attaches in those circumstances. So, final point to touch on, where next? Well, there are some proposed changes to the highway code. It's slightly unclear to me when they are proposed to actually come into force and what stage we're at. It seems that, like everything that's not COVID or Brexit related, it's slightly being put on a back burner. But the general suggestions are that there be a hierarchy of road users introduced, which ensures that road users who can do the greatest harm have the greatest responsibility to reduce the danger or threat that they pose. Clarify the existing rules on pedestrian priority on pavements to advise that drivers and riders should give way to pedestrian crossings or waiting to cross the road. Provide guidance on cycle priority at junctions, advise drivers to give priority to cyclists at junctions when travelling straight ahead, and establish guidance on safe passing distances and speeds when overtaking cyclists and horse riders. It seems to me that those proposals are clearly well-meaning and are helpful, but aren't likely to change the legal landscape very greatly, because they're all factors which the courts in general have been applying in the assessment of what's reasonable for road users to be carrying out. It might be slightly easier for cyclists to point to a direct breach of the code if we're talking about safe passing distances, for instance. But in reality, most of those cases turn on direct factual evidence. And what a judge does is look at those cases. And if it's caught on dash cam or CCTV, makes an assessment of whether what's being carried out is dangerous or not. And if it's not captured, they're reliant entirely on witness evidence and will have to make those findings. It will be difficult to make precise finding on exactly how far away people are or aren't as they pass. Ed, I don't know if you've got any different views on those proposals and how they might change matters.
No, I think, well, we can wait and see if the changes are introduced, and that's not yet been made clear. But I don't think the proposed changes would radically alter the way in which we would normally approach a case, save where there was a particular rule that applied to the facts of the case.
Yeah. Brilliant. We now have a few questions which have come in throughout. And if I deal with one, I think that was sent before, Ed, if I just read it out, and then if we perhaps pick another two from those that have been proposed. The first one that we had sent before was, in an RTA between a driver and a cyclist, if the accident occurred when it was dark, raining, and on a road with limited street lighting, and the cyclist was not wearing reflective clothing, what, if any, is the likely percentage of reduction of the driver's liability? Also, is there likely to be any reduction for contributory negligence if the cyclist did not have any lights on their bike? So essentially, we're talking about levels of contributory negligence for cyclists without reflective clothing and without lights. Ed, do you want to give us some initial views on this, or shall I start?
Yeah, I think it's an example of where when you look in the abstract, there's a danger in being too absolute, because first and foremost, you want to, as a starting point, consider the causative potency. And so as a motorist, you would have to be able to prove that it would have made a difference if they were wearing reflective clothing or if they were displaying a light on their bicycle. And so if it's a case, for example, where the motorist was looking at a text message or doing something egregious like that, then of course the court may not be in a position to find that it would have made a difference. But assuming that it is a scenario where the motorist was generally paying attention and just for whatever reason had not seen the motorist, and there was a finding that it would have made a difference, I think probably you'd be looking at something in the region of 25% for that sort of apportionment. I don't know whether you differ with that.
No, I think I agree. I might say that I think the failure to have lights on your bike is normally a slightly more causative factor than a failure to have reflective. So someone that's riding with lights but without reflective clothing, they're obviously likely to be much more visible than someone that's just with reflective clothing and no lights on their bike. So that can play into it, but it's difficult to know without having slightly more facts on the case. But certainly it's going to be a factor that's in the mix, and in any event can be used as a negotiation tool for however you want to carve up a settlement, whether it's actually recorded as a sort of a liability split or is simply taken into account in quantum.
One of the other questions that's come in is if you have a 5-year-old who runs out of a taxi into the road and gets struck, is there any scope for arguing that the parent or guardian who is also a passenger in the taxi should make a contribution to the claim?
A tricky one. So I think there's an authority on this. I think Williams and Williams, where contributory negligence was found on the part of a parent for failure to fit a child's seat or child's seating restraints correctly, and the child was more injured than they otherwise would have been. And I think is it Ellis and Kelly? There was a more recent judgment on that where no finding, I think, was made. I think that was a child playing in a park where they then ran the road because they weren't supervised, but they were slightly older at 8. I mean, I think in theory, yes, a finding is, there's nothing legally which excludes that finding being made. I think the courts are relatively hesitant to make such findings because it imposes such a sort of high burden on parents to parent in a particularly precise way. But it seems to me that the facts of that case, a 5-year-old getting out of a taxi into the road, one would expect a parent to sort of keep their child under control. I don't know the precise factual mechanisms of it, and it might be if they've got other children, they didn't expect them to be able to get out or expect the door of the taxi to be locked. But I think in theory, yes, a claim can be made. How easy it will be remains perhaps to be seen. Ed, do you agree with that? Or?
Yeah, I agree. I think in as a point of principle, of course, you could try to seek a contribution from a parent where you've got cases involving children, but I think you will find that the courts are reluctant. And so it's only going to be in circumstances where what the parent has done is quite egregious that you're likely to be able to get any traction with that, because I think this is an aspect where the courts are going to bear in mind the fact that most parents are very unlikely to have insurance against such a risk. And so, you know, that's essentially the policy reason for the reluctance.
Yeah. Just looking at the other questions. We have an argument about what our view is on contributory negligence arguments for motorcyclists not wearing protective clothing aside from helmets, for example, protective boots. What about a motorcyclist wearing trainers who sustains a degloving injury to his foot?
Yeah, I think, again, it's one of those issues where it's important to consider all of the facts and look at the particular case. So what sort of motorcycle is being used, because there may well be a difference between somebody who's driving or operating a low-powered moped to somebody who's driving a really powerful motorcycle. And so it will depend. I dare say that amongst the population that use mopeds and vehicles with a low level of engine power, that probably it's not the norm to wear protective motorcycle boots. And so in that sort of case, I think you might find that it's difficult. And obviously also you need to establish that causatively it would have made a difference. I think probably in the example that you give of degloving, it may well be the sort of case where you would be able to establish with expert evidence that it would have made a difference. And certainly I think there are cases where I'm pretty sure there is case law that considers that issue in the context. I seem to recall a case, I don't know the name of it, involving a police officer who had worked as a police officer on a motorcycle, but then had an accident in his private life. And I think there was an issue in that case as to whether the degree of apportionment in respect of not wearing motorcycle boots. So I think there is actually case law on that, and probably that's one that I'll be able to respond to. I'll look that case up and be able to respond to you privately after.
Yeah, I just say, building on that, I think it also depends on not just the vehicle that's being driven, but the roads that are being driven on. It's obviously much more reasonable to expect someone to wear full leathers if they're traveling on dual carriageways or motorways. Is it reasonable to expect someone to wear full leathers driving a 125 moped to pop to the shops 5 minutes away where they only wear on B roads? I think you took a fairly good argument. It's probably not reasonable. It's not reasonably foreseeable that the type of injury you're going to sustain might require you to wear something. Again, all factors for negotiation, but I think at trial, you might struggle on suggesting that someone driving within their village, for example, might need to wear full leathers. Should we do one more question, Ed? We're well over time, but as we've got them here. How much contribution could you expect when a pedestrian was intoxicated on a mobile and crossing on a stretch of road between two pedestrian crossings?
Well, I think if you break it down, it's always helpful, I think, to break things down into the individual allegations. And that's part of the way I think that it's helpful to reach an apportionment, to look at how many instances of negligence on each side and the causative potency. In terms of pedestrian crossings, I don't know about you, Michael, but to my mind, I tend to think that failure to use a pedestrian crossing, it's never immediately causative per se. Of course, it can be said that if you'd crossed on a pedestrian crossing, then perhaps the accident wouldn't have happened. But actually, I really often analyze that to be an aspect that just places greater emphasis on the duty that you have to make sure that it's clear to cross, because just because you cross the road doesn't mean that you're going to have an accident. You're entitled to cross the road wherever you so choose. You're just got to make sure that it's safe to do so. And so that's, I mean, again, we're talking about these things in the abstract. You'd want to look carefully at whether it could be said that the pedestrian had looked and kept a proper lookout, and it would depend upon the factual findings in relation to that. Using the mobile phone would tend to suggest that they weren't keeping a proper lookout. And so it seems to me those two things both point in the same direction, which is failure to keep a proper lookout being the fundamental cause from the claimant's perspective. And the fact of intoxication doesn't really add anything in my view. It's more just the failure to keep a proper lookout. And we don't know anything about the motorist here, so it's difficult then to reach an apportionment. But I would have thought, you know, anywhere either side of 25%, but it would depend, you know, that's assuming the motorist not having done anything particularly egregious. I don't know if your view differs to that.
No, I think you've covered it fairly thoroughly, Ed. We have a few more questions. I don't know if we want to try and deal with them now. There's still quite a lot of people left online. There are some that I certainly don't know the answer to. Is Barrow being appealed, or do we not know? I can ask Susan, and I'm sure she'll be able to tell me. I don't know. It seems a fairly factual finding in that case.
I was surprised it was factual, wasn't it?
About what happened. It seems to me that the judge made a finding that the claimant had slipped over beforehand. Obviously, I don't know the full background to that case and how it played out, but it seems to me that his findings were very much, factual findings. In respect to the other questions, I think if we will endeavour to get back to the people that have asked those questions via email, Ed, if you're happy to do that as well.
Yeah, of course. So thank you very much for taking the time to tune into our webinar. We're grateful for the time and the contact with you today.
Brilliant. Thanks very much.
Bye.